We'll move on to notice to ARC 8064C, June 12th bulletin, page 10,074. And I understand, Jack, we have presentation today on that rule as well, making a change again, right?
8064C is up right now, and the department circulated a couple of handouts that all members should have in front of them.
Everybody have those. Okay, awesome. Thank you. Go ahead.
Thank you. ARC 8064 is a notice filing. The chapter concerns consumable hemp products. These rules implement 2024 Iowa Acts House File 2506, and we combined this implementation with a red tape rule review. 2 public hearings were held virtually on July 2nd and July 8th at 3 p.m. and 10 a.m. respectively. 29 individuals attended the first hearing and 27 attended the second hearing. Public comments at the hearings were from consumers, retailers, and distributors of consumable hemp products, mostly regarding the serving and container limits proposed in the rules. Public comments were also received via email. We received 1 public comment with suggestions on how to reformat the warning language to better serve retailers that sell in multiple states. We plan to make those changes in our subsequent filing to reflect those suggestions. Another comment was from a Laboratory Accreditation Association regarding the proper way to reference accreditation for laboratories. We are planning to adopt that change as well. As mentioned, we have circulated a draft of our updated rules showing those changes for your information. With me, I have from our government relations team, Nick Crawford, who will be able to answer any specific questions you have surrounding this rulemaking. And Nick was involved in the legislative process for this.
Thank you. Any questions from members of the committee? All right, sounds good. Members of the public. Yeah, please take the seat up front. We'll get you a mic. Please identify who you are and who you represent, and then go ahead and ask your questions.
Good morning, Chairman and committee members. My name is Teresa Harms, and I'm here representing the Iowa Hemp Alliance, which was formed as an initiative between 2 groups representing organizations that advocate on behalf of Iowa's consumable hemp industry. Members of these groups include retailers, hemp farmers, distributors of consumable hemp products within Iowa. Accordingly, the Iowa Hemp Alliance is comprised of members directly impacted by the passage of ARC 8064C and can provide unique insight to the harm proposed by this regulation. The Iowa Hemp Alliance opposes the implementation of ARC 8064 because of the underlying statute and proposed rules are unconstitutional and violate other federal law. In addition to the proposal, the Alliance has submitted concerns over how the agency will ultimately implement the rules, given the ambiguity surrounding many of the requirements of the proposed rule, as well as the inability for many local businesses to comply with the proposed rule prior to its effective date. Today, I will address these issues and respectively urge the committee to delay the effectiveness of ARC 8064 until the end of the next legislative session, or at least 90 days following, to allow the Department of Health and Human Services to address these outstanding issues. First, many of the Iowa Hemp Alliance members are concerned their primary inventories and products will not comply with a proposed rule as its effective date. 50 to 80% of the members' products are expected to be prohibited under the rule and will be considered controlled substances under the new serving and container size requirements, synthetic prohibitions, and warning label requirements. One of the Alliance members' businesses has already shuttered in the face of the implementation of the proposed rule. Instead of clarifying the underlying statute and requirements, the proposed rules merely reiterate the THC limit serving size and containers that conflicts with the permittable limits authorized in the 2018 Farm Bill. Thus, producers and retailers of consumable hemp products will now be forced to dispose of a substantial portion of their inventory merely to attempt to repackage their products in accordance with the department's rule, even though these products are currently permitted at the federal level. And this is assuming they can even find an alternative products, as many of the manufacturers and suppliers have indicated that they're not willing to adjust their products to meet Iowa's new rules. To put this requirement into perspective, let me provide with an example of how arbitrary and wasteful this proposed rule operates in practice. Previously, a CBD oil product that could legally contain upwards of 81 milligrams in the entire tincture package, if 2 droppers, so 2 full droppers of the product equals 1 serving, that 1 serving could contain 0.27 milligrams of THC, which complies with the federal THC concentration requirements outlined in the 2018 Farm Bill. Now, the same product would only be legal under the proposed rule if it's repackaged into a de minimis serving size containers to decrease the total milligrams of THC to 10 milligrams per container. However, the proposed rule fails to institute consumer product limitations on such products, so individuals can still purchase 8 bottles of the same product to achieve what is currently marketed in 1 single bottle. Far from achieving public health goals, the proposed rule in operation only forces consumable hemp producers out of business by requiring them to arbitrarily package their product inventory without additional benefit for public health or consumers. Second, the department has generated confusion within the industry with respect to the department's statements regarding full spectrum and broad spectrum consumable hemp products. Full spectrum consumable hemp products may contain up to the federally allowed limit of 0.3% THC by weight, while broad spectrum consumable hemp products do not contain any THC. However, it is clear the department does not understand the difference between these products, as it has issued guidance documents that refer to these products interchangeably. For example, the department's issued guidance document regarding the Iowa Medical Cannabis Program and proposed rule. The guidance specifically addresses broad-spectrum consumable hemp products and House File 2605. Under this guidance, the department states that many pediatric patients use broad-spectrum oral form products that contain less than 4 milligrams THC per serving, but may contain greater than 10 milligrams THC per container. As noted, broad-spectrum products do not contain any THC, demonstrating the clear misunderstanding of these products in the industry as a whole. Given the conflicting statements made by the department with respect to full-spectrum and broad-spectrum products, members of the Iowa Hemp Alliance are unsure whether or not the proposed rule also affects broad-spectrum consumable hemp products or products that do not contain any THC. Finally, the Hemp Alliance members who have previously been compliant with the state and federal guidelines now face risk of severe criminal penalties if they found to be not compliant with the proposed rule. The Iowa Hemp Alliance already provides that consumable hemp products that do not comply with the law are considered controlled substances under Iowa law. Therefore, the proposed rule seeks to recriminalize non-compliant hemp products. As drafted, the proposed rule is extremely unclear and does not permit individuals or businesses to properly discern what behavior is illegal and how to comply with the law. Criminal terms are not defined, and specifics for how to comply with the provisions are not provided in the proposal. The vagueness also leaves the door open to arbitrary enforcement of the law by the department and/or law enforcement. Given the highlighted penalties for failing to comply with the law in conjunction with the poorly drafted rule, we believe the proposed rule should be delayed in order to clarify significant details of the legislation, as well to provide individuals ample time for industry to comply with the law. Even though we question the constitutionality and of the underlying statute and proposed rule, the actions we underlined in our testimony today are practical solutions that must be addressed in the rule to reduce significant burden placed on consumable hemp producers in the state. The Iowa Hemp Alliance urges the committee to issue a delay on the implementation of ARRC 8064C as we continue to work with the department and the courts to address many of the conflicting statements the department has issued with respect to the legislation and allow time for these businesses to come in compliance with the proposed rule. We appreciate the opportunity to provide this testimony today, and I'm happy to answer any questions. Thank you.
Thank you. Any questions for Ms. Harms? I do have a question before you go. So again, I apologize, I was having a conversation. The broad spectrum products, explain that to me like I'm four. What is a broad spectrum product?
So essentially, there's three different types of products. There's an isolate product that is CBD only. There's broad spectrum products that have CBD, CBN, CBG, other cannabinoids in addition to the CBD. It has flavonoids and other components of the plant in it. And then there's a full spectrum product that allows the up to 0.03. So it has THC in it. So it has the other cannabinoids, CBD, CBN, CBG, all the other components of the plant in addition to the THC.
Thank you. Mm-hmm. Yeah, go ahead. Yes, President Wilson. Yeah, before you guys go, so if you get up and get questions, anybody that gets up in front of us, we can ask questions of.
Yes.
So please, if you just sit down for a second, Representative Olson, go ahead.
Thank you, Mr. Chair. My question isn't to the panel. My question is to Jack. What type of delay could be imposed by us? Is it a suspension? Is it a delay? How many days, if you could?
So the committee's powers relating to a notice of intended action, which this is, are slightly less and slightly different than for an adopted rule. Since this is a notice of intended action, the committee cannot impose a session delay. The committee can impose something like a 70-day delay, although because it's a notice, the statute describes that as a suspension. The upshot being this committee, by a 2/3 vote, meaning 7 members, could vote to suspend the department from adopting this notice for 70 days, which in practice functions a lot like a 70-day delay that this committee more commonly does. It's just a different terminology because we are at a different point in the rulemaking process.
Thank you. All right. Thank you, Teresa. Go ahead, Brad.
Thank you. Are we afternoon? Good afternoon. Brad Epperly on behalf of the Iowa Grocery Industry Association. I didn't know that I was going to speak, and I don't have anything prepared, but was reflecting upon how we got here. And I just wanted to express some concerns, and that is, as you all well know, you all pass the laws, and it is for the executive branch to then interpret where necessary and enforce them. In this case, we don't have legislative history, but we have what bills and amendments and iterations of those bills were filed as they moved through the system. Here, the bill was brought by the agency, Department of Public Safety. And in that original bill, you can see it, I pulled it up myself to remind myself, there was, with regard to potency, and I should say, in this case, I'm just talking about the social beverages that we're all aware of and the negotiations that went on to get this language in the position that it is. The original bill provided that HHS would have rulemaking authority to determine what that appropriate potency was. Well, as you can see, the next iteration of the bill shows that it's 2 milligrams per serving and 10 milligrams per container. There was no more allocation to HHS to make that determination. The amendment that was filed by Representative Holt was itself amended, and it was amended, that amendment was signed by 13 representatives, many of them committee chairs. And we were all talking about the same thing. We all understood what a container was because they already existed. And so I can't speak to what the public safety's idea was with regard to serving size, but there was nothing governing serving size out there. We all just understood that we were there was one point in time we were negotiating on 5 milligrams per container. We were asking for 15, and we settled on 10, and the bill was passed. And now after the bill is passed, and within, I think, a week or so of the bill being signed, the agency comes out with guidance, contrary to what is quite clear in the code as to what we passed. The concern here is, again, I would put out the question, should we even have agencies drafting bills and filing them in the first place? That's your job. Maybe you could ask for their input. But I find it very problematic that an agency would file a bill, be involved, as they acknowledged beforehand, in the legislative process, registered for the bill ultimately that was passed, and then come up with rules that are clearly contrary to the plain language of the statute. If 10 milligrams per container doesn't mean 10 milligrams per container, then how are we to do our jobs up here? How are you to do your jobs? I just ask you to work with them as best you can to get this back on track as to where we all knew it to be, and not put these folks at risk, whether they be retailers or manufacturers or consumers. And I take any questions.
Thank you. Any questions for Brad from members of the committee? Mr. Epperly, I'm so sorry. Questions of Mr. Epperly from members of the public? Seeing none, thank you.
Thank you.
Next. Again, please identify yourself, who you represent, and then go ahead.
Good afternoon. Thank you, Mr. Chair, committee. My name is Scott Selix. I own a few different breweries here in Des Moines. I own Lua Brewing. I own a couple restaurants, and I also own Climbing Kites. I also recognize most of you. I was up here throughout the entire process of House File 2605 being negotiated, compromised, and like Brad said, like Mr. Epperly said, we all knew what we were passing when we were up here. I worked with all 13, I believe, representatives who signed the amendment that said that a hemp product can contain up to 10 milligrams per container, and I think everyone knew that all of my products contained up to 10 milligrams per container. I had text messages with many of you, including folks on this committee, talking about how Climbing Kites would be able to continue operating. And very shortly after that, we received guidance from the Department of Health and Human Services that made 90+% of my products illegal. We all know that wasn't the intent of this. I was up here every day saying, please help me save my business. And fortunately, you all worked with me. And we were able to do that by the text of the statute. What we have today in front of us is not that. I do have some questions. Am I allowed to ask questions to the department?
Yes, you are.
Mrs. Daniels, you mentioned in your opening statements that the quote, and I'm going to quote you here, the serving in container limits proposed in the rules. Do you remember saying that?
Yes, I did.
And you agree that the serving in container limits are in the rules?
Hey, 1 second. I'm going to need to get a mic in front of you, please, whoever's answering the question. And then I'm going to need you to turn your mic off when you're done answering the question, asking the question, and then please engage your mic so we can minimize the feedback. Could you please repeat the question for me, and then let's get this process down. Thank you.
Yes, the department published serving in container limits in its proposed rules. Is that correct? And I suppose it could be to either of you.
There were serving in container limits listed in the legislation, 4 milligrams per serving, 10 milligrams per container. Can I speak to the department's interpretation of that and in the rulemaking process?
I don't see a downside to letting you go ahead and expand on that. Go ahead.
Great. Thank you, Senator. Senators, representatives, as you know, House File 2605 did not provide a definition for serving or container in the legislation. The department believes that authority was granted to us via the rulemaking process in Section 4 of House File 2605, which states the consumable hemp product complies with packaging and labeling requirements which shall be established by rules adopted by the Department of Health and Human Services. We believe that in order to implement packaging and labeling requirements, definitions for serving and container must be established, which is why the department is confirming in its rules the commonly understood definition from the FDA's food labeling regulations, which states, a serving means the size or portion customarily consumed per eating occasion, expressed in common household measures, which is established in Table 2 of 21 Code of Federal Regulation 101.12. Thank you.
Go ahead, Mr. Felix.
Thank you. So you're relying on the packaging and labeling rulemaking authority to publish serving and container definitions. Is that right?
As I stated in my comments, the department is relying on the language from the legislation which states the consumable hemp product complies with packaging and labeling requirements which shall be established by rules adopted by the Department of Health and Human Services.
Thank you. I think this goes to show what we're dealing with here, and I'll get to what I mean by that here as I work through it. The serving and container limits proposed by the Department of Health and Human Services are a part of their rulemaking process. Those rules, according to the Department of Health and Human Services, went into effect on July 1, 14 days ago, long before this committee ever had the opportunity to hear what those proposed definitions would be. The Department of Health and Human Services is here telling you we're relying on authority you granted to us, but also we're not going to have our rules come back to you. We're just going to do it. I can tell you that there were serving size procedures in place prior to House File 2605. Every time we submitted a product to be approved by the Department of Health and Human Services, we had to submit the milligrams of THC per serving in every single container. We always had to do that going back to 2019. THC as a serving was approved very similarly to how alcohol is governed. For a serving of alcohol, it is 14 grams of alcohol. It doesn't matter how much liquid you're ingesting, it's 14 grams. And we've all seen this. We all know that one shot of liquor is a serving. We know that 12 ounces of a light beer is a serving. As that beer gets stronger, the serving size changes. We're not talking about how much water a person can drink. When we govern these things, we're trying to limit the amount of the intoxicating substance that the person can have. And it is federally defined in the U.S. for alcohol as 14 grams. This legislature defined a serving of THC as 4 milligrams. You all weren't concerned how many brownies I'm eating, right? You just weren't. You weren't concerned how much liquid I was drinking. You were concerned how much THC I was ingesting. And we were up here with you saying, yes, we agree. There should be regulations. We've always limited our products to 21 plus. We've always included warning statements. We've always wanted to be a good actor. I'm here again today. You all got sick of me 3 months ago. I'm back. And we know what was passed here. And what the department is proposing is not what was passed. The way they regulated servings that was in place when you all passed House File 2605, the second you all passed that, they said, no. Now we're going to define servings so that we get control back. You all took control away from them because you knew this was coming. You didn't want to shut our businesses down. You didn't want to shut her businesses down. You didn't want to shut anybody's businesses down. Yes, you wanted regulation, but you didn't want to make 90% of my products illegal. The warning label requirement, I want to go into that a little bit because I want to talk about how they've made it impossible for us to comply. I had a deadline, coincidentally, this past Friday. I had to submit art for our labels. And the art for those labels will be produced, the cans for that art will be produced in late September. We will eventually be able to package that product sometime in October, and it will probably come for sale, assuming we can get the department to approve it, sometime in November or December. We still don't have a warning label. The proposed warning label had typos, which the court called out. They're saying they're making changes. We don't know what those changes are going to be. We're trying to guess at what the warning label will be. There's a very good chance we will guess wrong because we don't know what it is. The department is saying that warning label requirement will go into place on September 14 or there, somewhere around there. I can't comply with that. And we would tell the department all of this if they would just respond. Every time we reach out and say, please don't do this, please listen to us, they say, no, there's ongoing litigation, we're not going to do it. And we're saying, we're only litigating because you're not listening. I want to make a final point here, and then I know I've taken up a bunch of time. It is not an exaggeration to say that I have no idea how to comply with this law. I was up here, I did everything right, I worked with all of you, and I have no idea how to comply. The department has refused to answer our questions. They've refused to work with you all in large sense. They're providing inconsistent explanations for why products were removed from approved lists with no prior notice. And so I do want to ask that question very directly. I've had every single one of my products removed from my approved list after July 1, even products that contain less than 4 milligrams in the entire container. Why were my products removed so that I cannot sell anything and I've been pulled from hundreds of Iowa stores?
So in regards to the approved list, just so you all have a little bit of background on how that works with our regulatory division, which covers cannabis. When a new retailer, a new manufacturer, when they go into our system and they would like to begin selling these products, they submit a product list that includes all the items that they would like to sell, or all the items that they would like to manufacture. Once they submit that list, the department has 30 days to respond to that, and that's laid out in our administrative rules in relation to consumable hemp. In regards to your products, if there was a new product list that was submitted on July 1 because of the law going into effect, the department would in effect have 30 days to approve that list. We are still within that 30-day window, which may be what I think you're referring to.
That's not what I'm referring to. I'm referring to products that previously were approved prior to July 1, that after July 1 have been removed from our approved list, that even many of them are below 4 milligrams in the entire can.
I would have to go back to our regulatory team in our compliance division and ask some more specific questions about this to provide a clear answer. I'd be happy to provide that to you all once we have a clear picture.
How long do I have to wait as a business owner to figure out why I've been shadow listed? I've been shadow banned. I've had 2 weeks where I can't sell anything. I finally get someone who might be able to give me an answer, and they're telling me, sorry, we're not going to answer. And I can guarantee you, once he goes back and asks the department, they're going to come back with the same email they've sent me already that says, ongoing litigation, we can't answer this. There's no way for me to get answers. I can't sell any products. I've been pulled from hundreds of stores, and they can't tell me why. And they're here in front of you saying, we're doing everything right, here's what's happening, but that's not what's happening in the marketplace. We have no idea how to comply. They have no idea how to comply. They're in over their heads. There's no way that this law can go into effect on September 14th because they don't even know what the law is. We don't know what the law is. They don't know how it's being enforced. And so what we would ask you, I'll give one more example. Tennessee passed a similar law last May that had limitations in place on consumable hemp products. For them, the limit was 25 milligrams per container instead of 10. Ours is 10. That was passed last spring. The full breadth of the law goes into effect January 1, 2025, and they did that because they realized it takes a long time, even if you know what the law is, to comply. 18 months. They gave us 4 weeks and said, too bad. And then once we tried to comply, they said, even the products that comply, we're going to pull from your product list. I would really encourage this committee to issue a session delay. They're not ready to implement the law. They don't know what the law is. They're not listening to what you all passed. They're not listening to consumers. They're not listening to retailers. They're not listening to manufacturers. And there is no way that this regulatory scheme can go into effect. Thanks for your time, and I'm happy to answer any questions.
Thank you. Yeah, we'll have some questions. Go ahead. Representative Olson.
Thank you, Mr. Chair. I'm not suggesting that this committee will do it, but let's assume that these rules are suspended for 70 days. How does that get your products back on the shelves?
It's a good question. I don't know because HHS won't answer us. We are in a ongoing litigation to try to get these very same answers. And just to be clear, we're not challenging the container limit. We recognize there should be potency limits to an extent in Iowa. I don't know how I get our products back. we're in a legal limbo. The courts brought up a number of times, do I actually have the power to redress this wrong? And we've had to argue to the court that the court saying, even if I find everything was wrong, do I have the power to do that? And we've had to try to convince the court, yes, you do. And you're asking me the same question, and I don't know the answer to that. Because despite saying serving container are in the rules, they started enforcing it on July 1 like it was in the statute, which you all did not put it in the statute. You were fine with the status quo as it was prior to July 1. So, I'm an attorney, I should say that. I work in this area a lot. I also own Climbing Kites. I don't know the answer to that. But I think at the very least, a session delay would send a message to the department that says, you're not doing what we wanted you to do, and you need to come back to the table, and we all need to work on this together.
Any other questions from members of the committee? Yes, Senator Buslow.
Scott, thanks for being here. Appreciate the presentation and passionate advocacy for the cause. Question for you, I guess, for a clarification on what this applies to, because I can go on climbingkites.com/shop-kites for those listening at home and buy. Right now, it looks like a 4-pack of 5 milligram THC pineapple passion fruit sparkling water, or 5 milligram THC peach prickly pear THC sparkling water, or 2.5 THC orange mango THC sparkling water, or I guess if I'm feeling adventurous, the 10 milligram THC mixed berry THC sparkling water. My understanding is your product is not manufactured in Iowa, it's manufactured somewhere else. Would these rules, this law, obvious it applied to cans that were on shelves in, say, Fairway, but does it apply to the mixed berry 10 milligram that I can go to climbingkites.com/shop-kites?
I'll give you a twofold answer. The first is, I don't believe it does. I believe that when you all passed a law that said up to 10 milligrams per container, we put 4 servings in that can with 10 milligrams per container, and we can sell that can in Iowa. Out of an abundance of caution, because the department has continually threatened to arrest us for felonies if we continue to sell products, we have pulled all of those products out of Iowa at our own cost with 4 weeks' notice, shipped our entire company out of state. So yes, you can see those on that website, and when you go to check out, we were the first company in this space in the entire nation that required you to upload a photo of yourself and upload a picture of your ID so that there was age verification, because we want to be good. We weren't required to do that. There was no age limit, but we spent that cost to do it. So when you go to check out, you'll do that, but you'll find that you can't buy any of those products right now. You could ship them to Illinois, we can ship them to Nebraska, we can ship them to Wisconsin, Minnesota, Missouri, Kansas, we can ship them everywhere. You cannot get that product here. You can order the 2.5 milligram. And that's not because we understand or agree with the law. It's because I have 3 kids. I have a wife. I grew up here. I don't want to get arrested for a felony. I've never been arrested in my entire life. So it looks like you can order them. You can't. And it just goes, I could give you other examples of the crazy hoops we have to jump through to operate. The department requires us to register every product in advance before we manufacture it. But they don't allow us to register a product until we've manufactured it. So I don't know if you can see the catch-22 there. In order to submit a product for registration, we have to potentially commit a felony and possess that product. And then we have to hope the department, with whatever interpretation they're using that day, says, yeah, we agree with you. And if we're wrong, I can be arrested. So I can't manufacture this product. And I know you brought up that we don't manufacture it here, but it's because when that product is sitting in our tanks at the brewery, if they come in and they say, hey, you're making this, and yes, it complies with what the legislature says you can do, but we haven't rubber stamped it yet, that's a felony. And they testify to that in court, that the only thing that differentiates legal products from illegal products is not what you all say. It's not what the legislature says. It's whether they have actually approved it in their portal that they created. So I can't produce it here. And I would like to. And if you're wondering where all of our mixed berry and pineapple passion fruit and peach prickly pear products are, they're in Illinois and Ohio. And so is our entire company. We want to produce this product here. We are the fastest growing hemp manufacturing company in the country. We're an Iowa company. I own Iowa restaurants and brews. I invest in real estate in Des Moines. But I can't keep this company here. And it's not because of what you all said. I worked with you. We found common ground. It's because of what they said.
Any other questions from members of the committee? Yes, Representative Young.
My question is directed to HHS. If I asked you the same questions as Mr. Seelix has asked you and emailed you, would your response be to me and us, you can't comment due to litigation? Why were the products pulled? How do they comply?
Which questions are you referring to, Representative?
Those two right there. Why were his products pulled? And what must they do to comply to get them back on the shelf?
I'll repeat what I said earlier. I need to go back to our regulatory team within our compliance division and find out exactly what he's referring to. I want to be able to provide accurate information to the questions you're asking today, sir. And just one other thing, can I clarify a couple points that he brought up earlier? Am I allowed to respond to that?
Yes, go ahead.
Okay. Because there's been some comments made that we have not been clear as an agency as to products that are in compliance, products that are out of compliance. I would like to direct members of the committee to the frequently asked questions document that you received before the hearing today. This document was first posted to our website as soon as we could post it, which was on May 24th, following the legislative session. And we answered a significant amount of questions from the industry that we knew that they were going to have questions about. We provided very specific examples about which products we believed would be in compliance and which products would be out of compliance. So if there's any questions about that, I would highly suggest you take a look at that. And you can see that it's clearly laid out. All types of products, beverages, gummies, syrups, any sort of edible products, that is all listed on there. And then we also provide examples of what would be in compliance and what we believe would be out of compliance.
Just a follow-up question to clarify your frequently asked questions. So I read through it when it was given to me this morning, but is it safe to assume that some of the responses in your frequently asked questions are contingent upon the fact that rules are approved to support the legislative intent of the bill that was passed by both chambers and signed by the governor?
Yes. Yes.
Thank you. Any other questions from members of the committee? Yes, Representative Sexton.
Thank you, Mr. Chair. This question I think is for Jack. So we've got noticed rules in front of us right now, and I can't remember the timeline for filed. Can you help me, walk me through the process here?
So the committee is looking at noticed rules today. Starting tomorrow, the department has the option to adopt these, or it can take longer if it wishes. That's the minimum. Tomorrow's the first day this could be adopted. If that follows the regular rulemaking process, depending on when they file it, it would be back before this committee in a couple months. The department also has the option to adopt it emergency after notice, in which case it would be effective when adopted tomorrow or some sooner date. Now, in that case, the adopted emergency rules would be reviewed by this committee again after they're published, but they would already be in effect.
So they could go in effect tomorrow if the department believes they're ready to go.
They could, yes. Now, if that were the case, the committee would still get to review them after they're in effect, once they're published in the bulletin again. The committee has the option to suspend emergency rules, so they would be in effect until the committee looks at them again, and then the committee could suspend them and take them out of effect for 70 days until the end of the next session. So sort of a parallel process to the usual 70-day delay or session delay process. The options available to the committee today are suspending the department from being able to adopt this for 70 days.
Just so I understand, because I think you raised a great point, so just so I understand perfectly. So if we do nothing today, the rule is implied to go into effect, the department can make that determination. They're back before us again when the rule is filed. I mean, not filed, noticed.
Well, this is the notice right now.
Filed, right? So when they're back before us when it's filed, and so that can take anywhere from, what was the timetable again, Jack?
They can adopt starting tomorrow. And again, they could use an emergency rulemaking process so it's effective starting tomorrow, or they could use the regular process and it would be effective in a couple months after this committee reviews it again. If they use the emergency rule route, it's effective tomorrow and this committee doesn't review it again until a couple of months from now, after it's been in effect for a little while. I can look at my calendar here and nail down exact dates.
So have they filed an emergency rulemaking on this? I don't see it on the. I'm asking for myself.
They cannot. So there's two different kinds of emergency rulemaking. We've seen several double barrels on the agenda today. And that's like a rule is adopted and made effective almost immediately. That's not the situation here. We have a regular notice of intended action before us right now, public hearing, public comment, everything normal. The emergency rulemaking scenario here would be the entire notice process is normal, but the back end of the rulemaking process is abbreviated, such that the rules are made effective upon adoption, which again, they are eventually published in the bulletin and reviewed by the committee, but not until they're already effective.
So at the time that they're actually filed, then this committee gets to review those again. And at that time, what are the committee's options for 70-day delay, session delay, objections? What are our options after they're already filed?
So, in terms of adjusting timelines, the committee would have the 70-day period and the end of the next session period either way. If the department does regular rulemaking, the committee gets to review the rules before they're effective, and then move that effective date out 70 days or until the adjournment of the next regular session. If the department goes the emergency route, the rules could be effective as soon as tomorrow or later, and then the committee is coming in after they're already in effect and suspending them for 70 days or until the end of the next session.
I'm just trying to educate myself, Jack, and I appreciate having your information to do that, which is challenging for me sometimes. But if they've not filed an emergency rule-making process now, which they haven't on this rule, right? So how are they able to take the emergency route to have them go into effect tomorrow? I'm confused.
So there is, and I didn't answer your question about objection. That's another power the committee has, but doesn't affect timelines. I can get to that in a minute. There is a minimum timeline when a notice of intended action, what we're seeing right now, when it's published before the department can adopt it. They have to wait a minimum of 35 days before they are legally allowed to adopt that rule. That 35 days for this notice of intended action is up tomorrow. So they cannot act today, but they could act starting tomorrow. You also asked about an objection. Which again, an objection on a notice of intended action doesn't really accomplish very much because a notice of intended action has no legal authority. If the department wanted to if the committee wanted to object to whatever is ultimately adopted, that has no effect on when the rule is implemented. An objection articulates a specific legal defect or defects the committee sees in the rulemaking. And that is typed up, published in the administrative code along with the rule, a description of whatever legal faults the committee finds. then in the event of litigation that relates to that specific point of the objection, the legal burden of proof is reversed. So ordinarily, when you take the government to court, you have to prove that the government did something unlawfully, at least when we're talking about administrative law. If there is an objection on a rule, and that is the point of the litigation, then the burden is reversed. So the government has to prove its action was lawful. So the government bears the burden of proof instead of the public. I will note on that, since I'm aware there is litigation ongoing, I don't know of any precedent for what would happen if an objection occurs mid-litigation. Typically, the idea is an objection goes in there and it sets the legal burden of proof before litigation occurs. So I can't predict what effect, if any, having an objection put in place after litigation occurs would have.
So just for clarification of myself, so since there's a pending court case now, any objection, well, the committee would not have grounds to file an objection today. We would have to wait to file an objection after they've been filed, correct? Or do we have can we object to notice rules?
The committee could object to notice rules, but no one sues over notice rules typically. It's just a notice of something that will eventually happen. So the committee could do that. I'm not saying the committee can't. I'm saying to make that legally fruitful, the committee, to have the objection mean something in a practical sense, that you would want to object to adopted rules, which do not exist as of yet.
So hypothetically, if you have a court case in the system now, we wait until they're filed, we file an objection, we present an objection to it, that would not have any impact on the pending court case, especially if the court case was resolved with a ruling prior to us issuing an objection. That would be for further court cases on the rule, correct?
I would, again, that's a novel situation, but I would think an objection, because the committee could object to any rule at any time. I wouldn't think if the committee objected to a 40-year-old rule, that would bring back to life any litigation over that rule in the past 40 years.
Thank you. I'm trying to clarify myself to understand what our process is, so I hope that was helpful. If anybody else has any questions on the process, that's all I'm trying to unearth here is what options we have going forward, where we're at in the process, what that looks like, what we can do as a committee, what we can't do as a committee. I got Representative Olson, but I've got people stacked up. Senator Winkler, I think you were next, so I'm going to go to Senator Buslow and come back to you, Representative Olson. Senator Winkler, go ahead.
Thank you, Mr. Chair. This would be a question to the department. What kind of documentation existed ahead of this this bill in regard to an individual registering or being able to sell products? Was that administrative rules, or what kind of documentation existed for a business to be able to sell a product in Iowa, a hemp product?
Senator, there were previous rules, previous legislation that the Iowa legislature passed, I believe it was back in 2018 or 2019, as it relates to the federal farm bill. I don't know the entire history about that, but that's kind of what it goes back to.
So what standard were you using prior to July 1 to approve the sale of products?
The standard that would have been in that legislation.
I'm trying to figure out if we suspend the rules, if that reverts to previous practice. That's why I was asking the question, because they do have existing documentation of approval of product sale. And it was the understanding of the legislation that we didn't change the container size. And so my thought is, I am not a lawyer, but I just am trying to find a resolution to the businesses that in good faith, had worked with the department since 2018 and now are finding difficulty because of new rules being enacted that might or might not be contrary to our legislation, at least contrary to the intent of the legislation. So,
thank you, Senator Winkler. I guess the question that you're asking would be, Jack, I'm going to look to you for that. I'm trying to paraphrase it, and if I do a horrible job, please correct me. So basically, you're saying that if we don't allow the rules presented to us today to go through, what impact does that have on existing customers in this space' ability to continue to sell their products? I guess the question I would have would be, without rulemaking, which the law specifically grants to Health and Human Services, is there even a law anymore? Because we've left out large chunks of we've left a lot of questions unanswered that were to be answered through the rulemaking process. Does that make sense, my question, Jack? I mean, at what point in time do you, or does that not make sense? I'm trying to parse it out in my head to see if that's accurate representation of your question or not, Senator. I don't know.
So these businesses have been operating since 2018, and they have been following regulations that were promulgated in one way or another by the department. By not allowing the rules, by suspending the rules, would those regulations still be in force?
The committee is looking at a notice of intended action that has no actual legal effect in and of itself. So whatever the pre-8064C status quo in terms of rules still exists, because this is just a notice. If the adoption is prevented for 70 days, the status quo today will persist for a minimum of 70 days. This 8064C is not changing the law. I'm not sure if I answered your question.
I think you did, Jack. Yes, I think that makes sense to me anyway. I think that answers your question, Senator. So yes, status quo is in effect unless the rule is adopted, which changes, which I believe that's the answer. So, Senator Buslow.
Thank you, Mr. Chair. Mr. Crawford, some questions came up in terms of the type of rule filing, and I appreciate that the department and the governor's office is trying to provide probably some certainty and clarity to the industry and to industry partners, stakeholders, and I certainly give you that credit. And it's been noted that there is no emergency rulemaking authority in the bill that was passed. You and I discussed this, but can you expand for the rest of the committee on the rationale under 17A for how these rules were filed and moving forward?
Absolutely, Senator. Thank you. So under Code Section 17A.5, the department has the ability to put forth a filed emergency after notice, and there's several scenarios where we have to provide our intent to do that. So I'll point you to the two that we're looking at here. Again, this is under 17A.5. Section 2, subsection B, subparagraph B and C. Subparagraph B reads that the rule confers a benefit or removes a restriction on the public or some segment thereof. Our rationale for that piece, in order to adopt these effective tomorrow, would be the sooner we adopt these rules, the sooner registrants in our state, manufacturers, retailers, consumers, have clarity about the direction of these rules. And then the second piece that we're also relying on there relates to subparagraph C that says that this effective date is necessary because of imminent peril to the public health, safety, or welfare. Our rationale there is that consumers need to be aware of the dangers of the products which they're consuming, and that would be further detailed in the warning label that we lay out in the rules that are before you today.
Can I just comment on that for a second? They just told you they're going to give you a warning label tomorrow that is effective tomorrow. I still have product on shelves in Iowa. They still have products. They are going to criminalize in an instant and make me a felon tomorrow. They just told you that. They just told you they want to make me a felon tomorrow, even though I'm trying to do everything they're suggesting. They don't understand the implications of their actions. They don't understand what you all passed. They're trying to criminalize a person like me. And Therese, we're up here all the time. There's no imminent public safety threat. Okay? It's been around for 4 years, but they can't wait 2 months to give us notice, or 6 months. It is the process, and I hate to say this because you don't want to use hyperbole, but it is baffling, the process they've used. They keep telling the court in our litigation, you don't need to act yet. This isn't final. This isn't final. Don't act yet. They sued too early. Don't act yet. And they just came and told you that they're going to make it final tomorrow. The double speak has been beyond anything I've ever seen. It's beyond what should be representative of our state government. And I implore you to please don't let these rules go into effect tomorrow. We literally can't comply.
Thank you. Representative Olson, as you on the list for questions.
One of my questions was going to be, are these rules going to go into effect tomorrow? And apparently the department says yes. Is that correct?
That is our intent, yes, Representative.
All right. With that thought in mind, I'm looking at the definition of what a warning label is, and that's in the handout that you gave us today. Have you folks actually approved of the language in a warning label? Because this definition indicates that it should include the following or substantially similar language. Have you folks got a template that producers need to have on their products? And if not, why not?
Representative, we did in our initial draft rules that we released back on May 24th have very specific warning label language that was included in those draft rules that we provided to registrants that we released publicly. What I can tell you is that through the public comment process, we did receive feedback from one of the public comments that if you use the prescriptive warning label language, it will create some extreme difficulties for manufacturers who sell these products in multiple states. So we received that feedback, took it, and then in the draft rules that you have before you today, we made changes that allow for some leeway in that warning label language so that you do not have to use exact language that is listed in the rules, but you can just abide by some general statements that you have to include in that warning label language.
So do you have a template?
We do not have an exact template. No, we received feedback that would be prohibitive for manufacturers. So we created in the rules. If you take a look at the draft rules, sir.
I've got them.
So let me get to the page here. At the bottom of the fourth page, you can see there that we used language that says a statement that the product has not been evaluated or approved by the USDA, the potential for the product to cause consumer to fail a drug test, a statement that products containing THC may cause impairment, a statement, and so on and so forth. You can read down the rest of the list there. We received feedback, as I mentioned during the public comment process, that would be easier for manufacturers to use statements, and we know that other states have done similar or use similar language in their rulemaking. So we heard that feedback, and we've put it in the draft rules before you today.
And if you could, when did the draft rule that I'm looking at that you referred to on page 4, when did that go to print? In other words, how long has this newly suggested language been out there in print?
Yep. So the language that you're looking at now, we've made two changes from the language that has been out there since June 7th. So the two changes that you'll notice are on page 1, which Victoria mentioned in her opening statements, regarding the definition of an accredited laboratory. We received feedback during the public comment process that the definition that we utilize for an accredited laboratory could be clearer, and so we included that language in the highlighted definition that you see here. And then also the warning label language that I just discussed with you.
So your answer is somewhere between July 8th and today, this went to print?
Sir, this is a draft before you. You're seeing this for the first. This is a draft rulemaking right here. We have not shared this exact language in the two highlighted sections that I discussed. So the laboratory language and then the warning label language, that is being shared today.
So when did it go to print? Yesterday? This morning? A week ago?
Sir, I'm not sure I understand what you mean by when it went to print.
All right, that's fair enough. Let me be more specific. The document that you folks handed out that says draft, when did somebody actually run this through a copy machine to provide us with our copies?
This morning, sir.
All right. So when was it typed? Or would it be keyboarded? I don't know. I'm from the east side of Des Moines. When did it get reduced to this form? Yesterday?
I can't give you the exact date. We've been working on these draft rules, which we released publicly for the first time back on May 24th.
Right, but they change, right? I'm talking about the copy that I have in my hand that's adopted the two changes that apparently came into being after there were public comments, and I think maybe the last public comment day was like July 8th or something like that. So when were they adopted, printed for distribution today? When I say adopted, typed.
I apologize I did not mean to interrupt there. My apologies.
That's fine. I have a tendency to hesitate when I speak.
Thanks,
Senator.
We followed the public comment process that is required through the rulemaking process. We received feedback and took that feedback and incorporated it into the rules the way that you have to incorporate them through the rulemaking process.
Okay, and what I have in my hand was distributed today, and it was copied and or printed in your department this morning. For distribution
yes.
Today. And someone must have worked on this then either early this morning or yesterday to get it in the form for it to be copied and distributed today.
Yes.
Which day was that? Yesterday?
We've been working on these rules since May 24th, Representative.
Fair enough. The point I'm trying to make, and maybe I'm not doing a very good job, is what was given to us today hasn't been circulated with the public, okay, in its final form. It hasn't been circulated with the folks to your left in its final form until today, and you're suggesting that you're going to implement this tomorrow. Is that what I hear?
Our intention is to implement these rules tomorrow, yes.
Thank you very much.
We've been at it for 2 hours. I'm going to call a 5-minute recess. We'll get a bathroom break in for anybody else that needs it. We'll come back. Please don't go anywhere. We'll continue the questions when we come back. So we'll take 5 minutes. We'll reconvene the ARRC committee. I do want to... There you go. Thank you, Representative Sexton. All right, we're going to reconvene. It was brought to my attention typically that during ARRC, it's up to the chair, but typically, witnesses don't get a direct question. Agencies, I want to apologize to HHS. That should have been routed more through the committee than back to you, which is kind of like that game we used to play on the playground where, we start off saying one thing, every time it gets to the end, it's completely morphed itself. So I was more along the direct, let's just get the questions answered. But again, it was brought to my attention. So I do want to apologize to the agency for allowing what should have been routed through the chair or through the committee, then back to the agency again. So anyway, having said that, we'll move on. Who's next to ask questions or make comments, please? Identify yourself, tell me who you represent, and go ahead.
Can you hear me? Yeah. I am one of the owners of Global Source Distribution and the Happy Can, collectively Happy Can, both of which distribute consumable hemp products to retail businesses in Iowa and surrounding states. Happy Can is registered and licensed with the Iowa Department of Human Health and Services as a manufacturer and retailer of consumable hemp in Iowa. Happy Can is required to submit products for approval with DHS through the Consumable Hemp Registration Portal. Given the new hemp amendments and the specifications required for the consumable hemp products, Happy Can developed a new product based on its understandings of the law and guidance issued by DHHS. Happy Can also developed a 4-serving drink with a total of 10 milligrams of THC, 2.5 milligrams. On July 2nd, 2024, Happy Can reviewed its portal, and all products, including the seltzer, which was 4 milligrams, were deleted and removed from the portal. Happy Can has tried to submit new products to the portal since July 1st, 2024, and was able to do so, but the functionality of the portal does not appear to work. The only way to currently upload products to the portal is manually, which means it must be done 16 times for every location, which can take hours. Further, there were only 6 products submitted to the approval on July 1, 2024. Happy Can has not received a notice as to whether these products have been approved or denied. As part of the new portal submission process, a THC milligram per serving and THC per container must be entered. If a certificate of analysis does not analyze the product or a per-serving basis, then Happy Can as a manufacturer is required to decide what the serving size are for their products. However, Happy Can was not previously required to provide this information through the product submission portal previously. The servings established in Table 2 of 21 CFR 101.12 as amended through May 27, 2016 doesn't contain a serving size limitation for dry weight component products. The consumable hemp product being sold by the Happy Can are measured as such. The same federal code chapter does go into partial analysis on weight-based serving components and says that the producer can state the serving sizes are varied. For example, if the product being submitted in a 12-ounce consumable hemp drink and the certificate of analysis only analysis the THC amount of the product as a whole, Happy Can is only required to do the math to determine how large or how small the serving size is in order to meet the specifications of the new law, based on how Happy Can is interpreted with the new laws and non-final guidelines of the new law. Further, while we understand that DHHS may take up to 30 days to approve product, neither Happy Can nor any other entities that Happy Can knows have had product approved at this time, which is seemingly in opposition to the role of DHHS as the approval agency. DHHS had a previous track record of approval of products on the website within 7 days, and in most instances in 1 day. As there are no discretion definition nor labeling requirements in the law and the amendment thereto, Happy Can administrative personnel have hired a compliance specialist in an attempt to address the amendments to the new age, the container requirements, and restrictions, revised all labeling requirements, serving sizes, and container requirements and restrictions based on interpretation of the restrictions of HF 2605. Attempted contact with DHHS officials and agents in an effort to ensure compliance with the amendment's new requirements, and attempted to partner with state officials and legislators in an effort to ensure that the consumers of the product are limited to those who comply with the law and amendments. Additionally, Happy Can has reached out to DHHS for guidance of these issues, but was told we would not be receiving any guidance on the product compliance due to the pending litigation that Happy Can is not a party to. That concludes.
Thank you. Any questions from members of the committee? Yeah.
Yeah, could you give us your name, please?
Ashley Hartman.
Thank you.
Any other questions from members of the committee? Members of the public? Seeing none, thank you.
Thank you.
Next.
Hello. My name is Earl Ramey. I am with ARRC Isle FSA Farm Number 1276, and I'm also working with Iowa Hemp Alliance a little. I'm a cannabis producer, and I grow for consumable hemp program products. I am also a consumable hemp manufacturer. I provide a 30-day supply in my 1-ounce tincture supplement, not one serving. HF 2605 affects our product and our customers severely. Prior to House File 2605, we have been compliant and selling with local primary care for the last few years. Now our product's even questioned by her because of all of this. There seems to be a misunderstanding during the Senate vote of House File 2605. Dan Dawson compares the state's medical program allowances are 4.5 milligrams of THC. This is false. The medical side is not 4.5 milligrams. It is 4.5 grams. That is 4,500 milligrams of THC compared to what a consumable hemp is allowed now. That sorry about that. Comparing that to the medical side, it's THC up to 800 milligrams in a product, and we're being overregulated from the 0.3% that's allowed federally. We believe because of that, the statute is too vague for the department to be adding further restrictions to it that will criminalize thousands of Iowans. Administrative agencies do not have that kind of authority. House File 2605 allows me to have 0.04 milligrams in my 1-ounce container. Our 1-ounce container contains approximately 28,349.5 milligrams of product, which is oil, and in that I'm only allowed 0.04. Federally, I'm allowed 120 milligrams of THC in that product. That's milligrams, not grams. Sorry about that, I'm a little behind here. The difference between what is a supplement and what is recreational, one serving needs to be established. I asked the legislation to also review September 2023's cannabidiol meetings where Dr. Schreck states he doesn't know if the regulation of consumable hemp products will put him back into a competitive market. I believe a lot of this is a misunderstanding of who's losing money over what. Other than that, I'm a farmer. I got into the hemp thinking that it was for farming, but the definition of hemp, it's isomers, salts and salts isomers. That's nothing a farmer's going to understand. That's pharmaceutical stuff and laboratory stuff. The reason I think that THC was still allowed in Iowa was because certain farms like mine doesn't have the molecular compound and structures as our white labeling medical manufacturers that are also consumable hemp manufacturers and retailers. We're being forced to, as a card holder, I've used the products since 2018, since CBD became legal. Iowa seems to have a misunderstanding that the CBD is illegal. It's been legal. Our aloe vera product that's offered on the medical side is consumable hemp. It's available for export. So we're being forced as a patient to get a card, which my card will cover a seltzer. A THC seltzer, my card will cover because it is a liquid. My card will cover out-of-state CBD products. I can go out of state and come back with the same products that I purchased at my local CBD store and legally hold them with this card, as long as it's not a smokable product. There's a lot of confusion in this, and being on kind of in the middle of all that sides, I complied. I sent my products in. They were approved. I'm on the shelf still, but I had to reduce my product by 3 milligrams. And again, there's 1,000 milligrams in a gram. This farm bill was wrote off a gram of marijuana, the intoxicating or effect was, related to on a gram of marijuana. This isn't, we're in milligrams. There's thousands in milligrams in the gram. It's confusing to me because after going through the legislative session, I look at this and I'm like, wow, it's more confusing than it is actual what's federally legal. And I had to go out and try a seltzer. And I tried a seltzer compared to what we were being as a medical patient or as a Iowan being advertised over and over on the radio is go get your med card, go get your med card. My doctor asked me about if I would be interested in the program. I didn't go to her and say, hey, I need THC. She said, hey, you need to supplement something. Would you like to get on this program? I said, yes. And in 2018, I did, not knowing that I was buying a federally legal product, but I had to have a medical card to do it. And if you look at the aloe vera product, it says available for export. And now we do have a choice as a patient to have either a consumable hemp product that's sold in that store or the medical product, which both are still white labeled products that other manufacturers make and ship in and out of state. It's just confusing. I think legislation should review the board before they make any decisions on making this a law, because as someone said earlier, we've been compliant for half a decade now, and all of a sudden there's a problem. I think that problem consists more from the actual medical cannabidiol program that once was. MedFarm's gone. It's Bud and Mary's now. They're moving forward into other and better things. They're a smart company. They have establishments all over the U.S., but their recreational products are medical products here, where you can go out of state and buy the same product as a recreational product. It's confusing. I don't think 2605 should ever even exist. I think everything was fine before it started. It's just now just a mess, and it'll cost of money to everyone. So that's all I got. If you have any questions.
Thank you. Any questions, members of the committee? Members of the public? Seeing none, thank you very much. Anybody else wish to speak today? Go ahead. Again, please tell us who you are, who you represent, and go ahead.
Good afternoon. I'm Catherine Lucas. I am General Counsel for the Iowa Department of Public Safety. One thing, reading the room a little bit, and if you are looking at any type of delay on these bills or the implementation of these bills, I asked the committee in this, Mr. Chair, you might want to ask Jack, because he knows more about rules than a lot of us put together, but to not throw the baby out with the bathwater. We've been talking a lot about the serving size and the container limits here. Another part of these rules that hasn't been talked about a lot is the ban on synthetics and the definition of synthetics. The ban on synthetics is provided for in the House File section 4. In the House File, and then in our rule, in the proposed rules, there is, the subsection of the bill specifically provides the definition of synthetic consumable hemp will be adopted by rules, and these are the rules that adopt that definition of synthetics. Synthetics are exceptionally unregulated. One of the ways we have described synthetics is I was not good at high school science, and these are the science nerds I probably made fun of. Figured out how to move the molecules around and things like that to make consumable hemp products particularly potent, but there's no regulation on this. This could be done in somebody, this is probably the equivalent of the college bathtub gin is what we were talking about, these synthetics. So I ask if you do delay any of this, and if Jack says you can parse out rules, we ask that you at minimum keep the synthetic part going forward.
Thank you. And Jack, that's the next question.
The committee can carve up a rulemaking if it wants to. There's no case law on how far you can slice it. I always at least caution against, cutting sentences apart. Carving it up so that it doesn't fit together isn't workable. So in terms of making a motion to do something, the committee would need to clearly understand and indicate what parts of this would be suspended and which parts would not be. That would perhaps raise questions for the department on, if the suspended part and the non-suspended part can function independently. Because the department may not be inclined to sort of adopt a broken portion of ARC 8064C. But the committee can do it if it can figure out how to carve it out.
Can the committee limit which portion of the rule is enacted through emergency rulemaking?
I want to say no, but bear with me 1 second. No, the committee does have powers that can exercise on emergency rules after the fact, but in terms of sort of preventative, at this point, the committee can only limit adoption, period, not different kinds of adoption. But yes, assuming this were adopted at some point, tomorrow or later, the committee could come back and then suspend portions of the adopted rule after it's in effect. But it can't do that preemptively.
Right, thank you. Makes sense. Anybody else wish to, I'm sorry, any questions for DPS? Seeing none.
Well, just a final comment that
Yep.
DPS fully supports these rules that HHS has put forward.
Thank you very much. Yeah, go ahead. Yes, Representative Olson.
Thank you, Mr. Chair. Do you know which portions of the noticed rules that you would like to save should there be a 70-day suspension? Could you tell us what those would be so we don't overstep?
Well, I would like them all saved. At minimum, the definition of synthetic consumable hemp in the rule, or excuse me, in the definitional rule, so 156.1, it's the last definition there. If you're looking at the one I am looking at, I think if we want to just go through it, I don't think there's much of an objection anyone thinks on the definition of container. That seems pretty self-defining.
Just to back up, I'm sorry to interrupt you, but you were talking about the synthetic consumable hemp products definition.
Correct.
And then below that on the one I have, and I'm going to butcher this, we have tetrahydrocannabinolic acid and total delta 9. So there's two more definitions below that. Are we still talking about the same definition?
Correct, yes. Those are existing definitions in the rules, and we'd obviously want them to stay. This amendment for the definition of synthetics, we would for sure like to be continued. Excuse me, implemented.
Senator, if I may.
Yes.
Sort of a further wrinkle now that I continue to think about this. So the posture of this rulemaking is rescinding the existing chapter and then adopting a new version of the chapter. So I would want to clarify if the desire here purports to be keeping parts of the existing chapter, and then is there an attempt to retain some parts of existing 156, or is the question existing 156 is rescinded and then portions of new 156 go into effect?
So my understanding would be, and correct me if I'm wrong, Jack, so we're looking at suspending portions of the rules that would go into effect as a result of emergency rulemaking power, which would not be all of 156, right? Or
well,
am I not
it suspends from adopting regardless of regular adoption or
make any
emergency
difference?
adoption. Okay. But there is a whole chapter of rules going away. You know, the item statement says rescind 641, chapter 156, adopt the following new chapter in lieu thereof. So the committee would want to take care to make sure that if not all of, to just be purposeful on, because I don't want to speak for Catherine on what exactly she's asking for.
Understand.
Mr. Chair, and I don't know if this is an option for you to ask Jack too. Is it easier to say what parts you don't want to be enacted?
I think from the committee's perspective, that would be simpler and would ensure that we don't unintentionally unring a bell that needs to remain rung, which would be eliminating all of the rules from Chapter 156, which would be a byproduct of us doing a delay on those then. Jack, is my understanding?
So there are sort of two actions going on here. Old 156 going away, new 156 coming into place. So merely suspending the department from adopting certain portions of new 156 in and of itself doesn't stop the old chapter from being rescinded and going away. So not taking a position, of course, on what the committee should do, but the committee should be purposeful on the differences between the old Chapter 156 currently in effect now and the new proposed Chapter 156.
Does that answer your question?
Yes, I am just, well, again, we don't want anything delayed, but there's the only portions in here that the parties are having issues with in the litigation and today are the serving size piece and the warning label piece. There's significant other portions in this amended rule that we would really need and really like to move forward with at minimum. I'm looking, the issues with the certificate of analysis has to be less than a year old. No one's thinking that's a bad idea to know how recent those things are. That, you know, HHS wants the authority to, that the testing laboratories these places are using are good too. So there's a lot of really, really good stuff in here besides the two issues that people are taking issue with.
Understood and agreed. Senator Winkler.
Thank you, Mr. Chair. In this conversation of trying to piecemeal what we potentially want to delay, I think the unintended consequences of that are larger than just putting a delay on all of it. And I would advocate for not trying to rewrite rules in committee and put a delay on it. We know that we have some flexibility in bringing additional rules forward, potentially at our next meeting, but I am not supportive of piecemealing our conversation and creating further unintended consequences. Thanks.
Thank you, Senator. Anyone else wish to speak on the committee? No questions. Anybody from the public have any comment? Yes, please I need you back up on the. Yep. And then reintroduce yourself, please, again, if you could.
Earl Ramey with Iris Isle. I'm a hemp farmer. I've noticed a lot of regulation on THCA. It is not intoxicating. This caused me to go to 0.48. I was in compliance with my grow, but with the DPS implementation July of 23, regulating THCA into the consumable hemp side caused me to destroy $356,000 of my product, and it was at 0.48 with the THCA added. I understand the THCA on a flower side of the market and being sold and being grown in high THCA. If you look at Illinois, THCA is high as 30% in some of their products, but their THC is still below that 1% federal legal, so they're still somehow there. It plays a role. I understand it with the DPS, but as a farmer regulating the THCA as the non-intoxicating cannabinoid, it is not. It doesn't make sense. It doesn't make sense on a farming side, but on an authority side, it kind of does. But it's hurting. It's hurting. Like I said, my product. It put my product from 0.3 to 0.48, and I had to destroy $360,000 worth of product last year because of it. And it was under 1% federal. You know, they'd federally consider a cop would before he arrests you with it. It was brought my product barely over, but I couldn't use it because of the THCA being implemented into that. And it was a certified DEA lab, and that I get my test through. Thank you.
Thank you.
Can I quickly ask, just where do you farm and where are you from?
I own Iris Isle in Winterset, Iowa. Okay. My legislator is Ray Sorensen and Amy Sinclair. We had worked on this. That's why I mentioned the whole isomers, salts and salts isomers in the Hemp Act. It doesn't make sense for farming at all because it's not farming, it's big pharma. I've learned a lot through this. I've learned a whole lot through this and a whole lot working with legislation, and I understand, you know, the 21 and older law. I understand why they implement these laws. They cross with people who are doing things legally. And I've talked to Catherine before. I asked her questions in the beginning of it. I had Robin Prusner was here. She was the one who helped me get my stuff started through the agriculture department. And I told her I was going to take it slow. I didn't want to jump in because I knew big industry was involved in it, and there was influences there that they were trusted through the medical side in the beginning. And now we're past that med farm legal CBD product into now a marijuana for medical facilities. You know, that's why a lot of people are turning to CBD on the hemp side, because there's a lot more natural product there, and it just makes more sense financially, and you know what you're getting, because when you look at that label, it tells you what's in the product. And the synthetic versions, I totally agree with not having synthetic version, because as we move forward into this whole cannabis thing, it's going to make a stronger product as it becomes more legal. But anyway, it's the same plant, marijuana, hemp, it's cannabis, and I have to come in compliance to make it a consumable hemp product. So all this is kind of confusing to me too.
Thank you. Any other questions? Seeing none. Yes, Teresa, speak one last time.
My apologies,
Yeah.
Teresa Harms, the Iowa Hemp Alliance. We've had a lively discussion since I first opened up the conversation on this topic. Just a couple of things to note. So synthetics pose the same issues for manufacturers and retailers as container and serving size. So I discussed three things: the warning label, the container and serving size, and synthetics being an issue. And then they are unclear and unconstitutional in view of the Farm Bill. The 21, so if you want to look at something specific, I prefer that you take the 70-day delay. That's our request on these rules as litigation continues to make its way through the federal courts. But the 21 and over should address all of your safety concerns in the short term. So if there's one component, that would be one. But a delay to everything gives the industry some grace. The litigation challenges the law in its entirety, not just certain provisions, as was suggested earlier by the Department of Public Safety. And synthetics is just one of those pieces, mostly because of how synthetics has been defined in code. So because it is a part of the plan, some of those components that are defined are part of the plan. Thank you.
Thank you. Any questions? Okay, and that's everybody that wished to speak on this topic? Awesome. 30 seconds. 30 seconds.
I'm cognizant of your time. Thank you very much. I just want to say that if you issue a session delay here, a 70-day session delay, the 10 milligram limit, it's in the statute, it stays. The 21 plus is in the statute, it stays. The only thing you're delaying are the rules. So all of the protections you put in place will stay if you issue a 70-day delay today. Thank you.
Thank you. Anybody else wish to speak on this topic? Any questions from members of the committee? To Health and Human Services, who've been very gracious with your time on the dais. Thank you so much. I'm going to call for about a 10-minute delay while I compose my thoughts on this. We've got a lot of conversation points moving around. I need to spend a couple seconds. Plus, I never made it to the bathroom the last time I called the break. I got hung up outside. So we're going to reconvene in 5 or 10. Let's everybody just catch a breath, and we'll come back. One right close across the way, because I would have not made it all the way probably downstairs. Having dispatched that, any further conversation or discussion on notice ARRC 8064C from the committee? Yes, Representative.
Can, as far as anything else on this, I would like to make a motion.
It's your right to make a motion, Representative. Feel free.
Okay. Sorry, I didn't want to miss my opportunity.
Try to give the opportunity to finish up any conversations, any last minute talks. If anybody wishes to make a motion, whatever direction you want as a committee, I'm just trying to make sure that we get that, so everybody feels they've had an ample opportunity to air this out and have these conversations before we walk away.
I'm willing to hold off. I just wanted to make sure we didn't move on too quickly
No,
past that.
I think we're ready for it. Yeah.
Okay. Okay. All right. Well, then I would move that we ask the department to suspend adopting notice rule 8064C in its entirety for 70 days.
I have a motion for suspension for 70 days. Any second on that? I do not. So anybody wish to speak to the motion? Any conversation on the motion? Senator Winkler, yes.
I think that it's more a reiteration. It really, this particular rule was given to us and even amended as early, more or less, as this morning. What is here is not even, has not been made public other than the copies that exist. And I really do think that this requires more consideration and making sure that the alignment of the rules are exactly to the bill, and there are some differences. I also do not see rationale behind the imminent danger in regard to the decisions that the department has made, and I would support the amendment. I think that we need to, with the businesses at stake, with the health of individuals, with the clarity of exactly what it is that will be implemented, I think that we need to suspend and give it the 70 days. Thank you.
Thank you. Senator Bolton.
Yeah, I also speak in support of the motion, and I think what we're learning here is trying to do this on the fly is problematic. And we've heard very legitimate concerns from people that are affected by this, and I appreciate Representative Olson drawing attention to the fact that here we are looking at a proposed required warning label that was apparently just drafted yesterday that's going to maybe be implemented in effect and enforced with criminal penalties tomorrow. That's pretty fast to ask people to react with criminal consequences. I think the motion on the table allows us to take that time to make sure this is done the right way. I appreciate the concerns from DPS regarding the synthetics. I think an emergency rule could be dealt with through the agency to address that concern separately. But I think for what we have as a whole package here, rather than trying to carve this up and make more of the problem today that we're concerned about coming into this meeting, I think this timeout is necessary to make sure this does what it's supposed to do.
Thank you. Anyone else wish to speak to the motion? Seeing none, Jack, call the roll.
All right, the motion is for a 70-day suspension from adopting the entirety of ARRC 8064C. Requires 7 votes to pass. Senator Clemish.
No.
Representative Bergen.
No.
Senator Bolton.
Yes.
Senator Brusilo.
No.
Senator Knoyer.
No.
Senator Winkler.
Yes.
Representative Nielsen.
Yes.
Representative Olson.
Yes.
Representative Sexton.
No.
Representative Young.
No.
The motion fails.
With that, I call the meeting of ARRC to adjourn. Sorry, am I missing something? Oh, I'm not trying to run. It's just been here. I'm not trying to exit early. I just figured if that was the motion on the table, and we were done with it. Is there further action, further conversation? Senator Winkler.
So by not suspending, these rules go into effect tomorrow? Is that my understanding?
Yes, Senator, that's my understanding as well, yes.
With the full penalties in force?
Yes, Senator, that's my understanding as well, yes.
Thank you.
Yes. I would like to make the comment that we're going to get a chance to revisit these rules at some point in time. And by that time, we'll have clarity on the pending court case. So I look forward to having an opportunity to have this conversation, in a couple of months or sooner if need be. But yes, that's my understanding as well, Senator. Anyone else wishes? Yes, Representative Nielsen.
I think that those of you voting no have really just kind of seceded your legislative powers. We knew what we voted on when we passed 2605. Representative Young, you were a sponsor of the amendment that took care of the container and serving size issues, and quite frankly, HHS has mishandled this whole thing. If you were there for the whole entire legislative process, you know what the legislative intent was, and you're going against it, just flat out going against it. The financial damage that will be done to Iowa businesses, I think, is probably immeasurable right now. That's the imminent danger. You're making the imminent danger with these rules. And quite honestly, I think you should be ashamed of yourselves for not taking these back after all of the conversation that you've heard, after all of the questions that you cannot answer. This is disgusting. This is not how it's supposed to work. And I'm really disappointed in all of my committee members who think that this is a good idea to let HHS just take all the power away from us.
Thank you, Representative. Anyone else wish to speak? Seeing none, at this point in time, I call this meeting of ARRC to a close.